You're tuning into the deep dive because you want to get smart, fast on topics that matter. Today, we're laser focused on a really pivotal moment in Second Amendment history.
Yeah, we're talking about how the right to bear arms moved beyond just, the federal government.
Right, how it became a check on state and local power, too.
Exactly. And for that, we're diving deep into McDonald v. City of Chicago. This case is pretty much the key to understanding how the Second Amendment's protections apply, well, everywhere. To your state, your town.
And it didn't just appear out of nowhere, right? It built on earlier cases.
Oh, absolutely. It wasn't a standalone decision at all. It built on some really crucial groundwork laid by earlier Supreme Court cases.
And you mentioned a couple of those in the Prep DC v. Heller, obviously, but also a connection to a Fourth Amendment case, Mapp v. Ohio, which sounds interesting.
It is interesting. It shows a pattern, sort of, for how these fundamental rights get applied more broadly. So that's precisely our mission today, to unpack McDonald.
Yeah.
We want to understand how the Supreme Court decided that, yes, the Second Amendment does apply to state and local governments.
And how Heller kind of paved the way for that.
Right. And we'll also explore that parallel with Mapp, this whole idea of the Bill of Rights, setting fundamental standards for everyone, no matter if it's the federal government or your city council trying to make a law.
Oh, okay, sounds good. So let's start with that foundation then. DC v. Heller. What was the core issue there? What happened?
So Heller, that was back in 2008. It centered on a really strict handgun ban in Washington, D.C.
And D.C. is federal territory, not a state. That's key here.
Crucial point, yeah. So the Supreme Court's big takeaway from Heller was that the Second Amendment protects an individual's right, not just a collective militia right.
An individual's right to have firearms.
For traditionally lawful purposes.
Huh.
And self-defense in the home was flagged as like the prime example, the core of that right.
And the court really dug into the text of the amendment itself, didn't they? How it's actually written.
They did. It's quite fascinating how they parsed the language. You've got that first part, the prefatory clause, about a well-regulated militia.
Right, the part everyone debates.
Exactly. And then you have the operative clause, the right of the people to keep and bear arms shall not be infringed.
Okay.
So the court made this key distinction. They said, look, the militia part explains why the right was considered important back then for state security.
Right.
But it doesn't limit the right only to people in a militia.
So the second part is the actual right being granted to the people.
That's how the Heller court saw it, yes. The operative clause, they said, clearly states an individual right. The why gives context. The what is the right.
That makes that argument much clearer. And they looked beyond the text, too, didn't they? Into the history.
Absolutely. They didn't just look at the words. They went way back, examining English common law, the debates during the founding era, the ratification discussions.
Trying to figure out the original understanding.
Precisely. And their historical analysis, well, it's strongly suggested that the idea of an individual right to arms for self-defense was pretty well established, even before the Constitution.
Okay, so Heller establishes this individual right, very clearly tied to self-defense in the home, but it's specifically about federal law because it's D.C.
Exactly.
Which naturally leads to the big question for McDonald, does this right also limit what states and cities can do?
That's the million-dollar question Heller left hanging. It teed up the whole issue perfectly. Does this fundamental right apply everywhere, or just under federal laws?
Enter McDonald v. City of Chicago. What was happening in Chicago? Similar situation.
Very similar, yeah. Just 2 years after Heller, 2010, the court takes up McDonald. Chicago had its own handgun ban. Now, it wasn't identical to D.C.'s. There was some registration hoops to jump through, but it was so restrictive that it effectively prevented most ordinary people from legally owning a handgun.
So Otis McDonald and others sued the city.
They did. Otis McDonald, other residents, they sued Chicago, basically saying, hey, this ban violates our Second Amendment rights.
But they couldn't just say Second Amendment right, because Chicago isn't the federal government. They had to use a different constitutional route.
You nailed it. That's the crux of McDonald. Their argument wasn't just the Second Amendment applies directly. It was that the Second Amendment right, the one Heller defined, should apply to Chicago through the 14th Amendment.
Ah, the 14th Amendment. Okay.
Specifically, they argued Chicago's ban violated the Due Process Clause of the 14th Amendment.
Because it infringed on a right so fundamental, it should be protected against state action, too.
That was the core argument, yes.
Okay. The 14th Amendment and this idea of incorporation, it always sounds a bit technical. Can you break that down?
Sure. It can seem like legal jargon, but the basic idea is pretty straightforward. Originally, the Bill of Rights The first 10 amendments only restricted the federal government,
Not the states.
not the states. Then, after the Civil War, we get the 14th Amendment. One part of it, the Due Process Clause, says states can't deprive anyone of life, liberty, or property without due process of law.
Okay, fair procedure.
Right. But over time, the Supreme Court interpreted liberty in that clause much more broadly. They started saying that some of the rights listed in the Bill of Rights are so fundamental to, well, liberty, that the 14th Amendment incorporates them.
Meaning they now apply to the states, too.
Exactly. It's like the 14th Amendment acts as a bridge, carrying those fundamental federal protections over to limit state governments as well.
So it's like saying, these rights are just too important. States can't violate them either.
That's a good way to put it.
Yeah.
But, and this is important, the court doesn't just incorporate everything automatically. They have a test.
A test for what gets incorporated.
Yeah. They ask, is the right fundamental to our scheme of ordered liberty? Or sometimes they phrase it as, is it deeply rooted in this nation's history and tradition? That's the hurdle a right has to clear to be applied to the states.
And you mentioned a case, Duncan v. Louisiana. How does that fit in? Does it show how the test works?
Exactly. Duncan, from 1968, is a great example. It dealt with the Sixth Amendment right to a jury trial in criminal cases. The court asked, point blank, is having a jury trial fundamental to the American scheme of justice?
And what did they find?
They looked at the history, the role of juries preventing government overreach, and concluded, yes, it is fundamental. So through the 14th Amendment, the Sixth Amendment's jury trial guarantee was incorporated, applied to the states.
Okay, so that provides a blueprint. The McDonald court likely used similar reasoning for the Second Amendment.
Very similar. They looked straight at the right. They'd just defined 2 years earlier in Heller the individual right to keep and bear arms for self-defense and asked that same question. Is this right fundamental? Is it deeply rooted?
And what did they conclude?
They concluded, yes, it is. They explicitly referenced Heller's findings about the historical importance of self-defense. They said this right is fundamental, deeply rooted in American history and tradition.
And because it's fundamental,
The 14th Amendment's Due Process Clause incorporates it, makes it applicable to state and local governments like Chicago.
that's the key step. It bridges the gap from federal only in Heller to state and local in McDonald.
That's the bridge. And that finding directly led to the court striking down Chicago's handgun ban.
Why? Because the ban violated this now incorporated fundamental right.
Exactly. The court said Chicago's near-total ban went too far. It infringed this fundamental right protected against state action by the 14th Amendment.
So stepping back, Heller and McDonald, the holdings seem really similar on the surface. Both affirm an individual right to have guns for self-defense.
That's the core similarity of the outcome, yes. An individual right for self-defense is affirmed in both.
But the crucial difference is the reach of that right.
Precisely. Heller established the right against the federal government. McDonald took that established right and, using the 14th Amendment's incorporation doctrine, extended its reach to limit state and local governments too. Heller defined it. McDonald applied it broadly.
Now, you also mentioned that the specific facts in both cases were really important. How did the nature of the laws in D.C. and Chicago play a role?
Oh, hugely important. The facts were pretty stark in both Heller and McDonald. We weren't talking about minor regulations here.
Right.
In D.C., you had an outright ban on possessing handguns in the home. In Chicago, the regulations were so convoluted and restrictive, they are into pretty much the same thing for most lawful citizens, a near-total ban.
So the court wasn't dealing with nuanced stuff like, say, waiting periods or background check laws in these specific cases.
Not in these foundational cases, no. They were confronting laws that essentially banned outright the most common firearm used for self-defense, the handgun in people's homes.
And that directly clashed with the core right identified in Heller.
Exactly. The court saw these bans as a direct assault on the heart of the right.
Yeah.
The ability of a law-abiding citizen to have a common weapon for self-protection, where arguably the need is most acute in the home.
So because the McDonald court agreed this right was fundamental, they viewed these state and local near-total bans as just as problematic as the federal one in Heller.
Right. The extreme nature of the bans made the constitutional conflict very clear. It wasn't a borderline case. It was about whether states could completely prohibit this fundamental right.
That makes sense. Okay, let's switch gears slightly to this parallel you drew with Mapp v. Ohio. Fourth Amendment, illegal searches. Seems like a different world. What's the connection?
Yeah, on the surface, totally different amendments, different issues, search and seizure versus guns. But the connection, the common thread, is that 14th Amendment incorporation process we've been talking about.
Okay.
MAP is another classic example of the court taking a right that originally only applied federally and saying, nope, this one's too important. It applies to the states, too.
So remind us briefly, what was the issue in MAP?
So MAP v. Ohio, 1961, police searched Ms. Lee's Mapp's home in Ohio without a proper warrant. They found some materials. She was convicted based on that evidence.
Okay. And there was already a rule about illegally seized evidence at the federal level.
Yes, way back in 1914, a case called Weeks v. United States. The court created the exclusionary rule for federal trials. Basically, if federal agents violate your Fourth Amendment rights against unreasonable searches to get evidence, that evidence gets excluded. It can't be used against you in federal court.
A remedy to deter police misconduct.
Right. But, and here's the parallel to the Second Amendment before McDonald, that exclusionary rule initially only applied to the federal government.
So states could still use evidence even if their police got it illegally.
For almost 50 years after Weeks, yes. States weren't required by the Constitution to exclude illegally obtained evidence. Different states had different rules.
Until MAP.
Until MAP. The Supreme Court in MAP confronted that exact issue. Should this exclusionary rule, designed to enforce the Fourth Amendment, also apply to state courts via the 14th Amendment's Due Process Clause?
And they decided.
They decided yes. They essentially said the Fourth Amendment's protection against unreasonable searches and seizures is fundamental, and the only effective way to enforce it is to exclude illegally obtained evidence. So the exclusionary rule was incorporated, made binding on the states.
So just like the right to have a handgun for self-defense was deemed fundamental in McDonald.
The right to be secure against unreasonable searches, enforced by excluding illegal evidence, was deemed fundamental in MAP.
And both rights were then applied against the states using the 14th Amendment as the vehicle.
That's the core parallel. Both McDonald and MAP involve the court identifying a fundamental protection in the Bill of Rights and using the 14th Amendment to say, states, you have to respect this too. MAP limits how states can use evidence. McDonald limits how states can restrict gun possession for self-defense. Both expanded individual liberties against state power.
And there was a prior case MAP overturned, wasn't there? You mentioned that.
Right, good point. MAP explicitly overturned a 1949 case, Wolf v. Colorado. Wolf had weirdly said that the Fourth Amendment itself applied to the states, but the exclusionary rule, did not.
Which seems kind of ineffective, a right without a real remedy.
Exactly what the MAP court thought. They said the right becomes hollow without the remedy, so MAP fixed that. In a way, McDonald didn't overturn Heller, but built directly on it, providing the mechanism incorporation to enforce the Heller right against the states.
Okay, got it. So McDonald establishes this individual right applies everywhere. Does that mean states and cities are just out of luck? Can they pass any gun control laws now?
No, not at all. That's really important to stress. The Supreme Court and McDonald, just like they did in Heller, went out of their way to say the right isn't unlimited.
Okay.
They reiterated language from Heller, suggesting that many types of reasonable restrictions on firearms would likely still be constitutional.
Like what kinds of restrictions? Did they give examples?
They did, echoing Heller. Things like long-standing prohibitions on felons possessing firearms or laws forbidding guns in sensitive places like schools and government buildings. Those were mentioned as likely permissible.
So McDonald set a floor, a fundamental right to possess for self-defense that applies everywhere, but it didn't draw the exact ceiling for regulation.
That's a perfect way to put it. It established the baseline, right, but didn't provide, a detailed checklist of exactly what counts as a reasonable restriction versus an unconstitutional infringement.
And that ambiguity, I assume, has led to more court cases since then.
Oh, absolutely. That lack of a precise test in Heller and McDonald has fueled tons of litigation across the country. Courts are constantly grappling with where to draw the line for specific types of state and local gun laws, assault weapon bans, magazine capacity limits, carry restrictions, you name it.
And the Supreme Court itself has revisited the Second Amendment since McDonald, right? Like the Bruin case recently.
Exactly. The legal landscape is definitely still evolving. New York State Rifle and Pistol Association v. Bruin, agended in 2022, addressed the right to carry firearms outside the home and introduced a new test, focusing more strictly on history and tradition for evaluating gun laws. So the conversation continues.
Okay, let's try and wrap this up. Our deep dive today really focused on McDonald v. City of Chicago. We saw it as this crucial step.
A landmark ruling.
That took the Second Amendment's individual right to bear arms for self-defense, which Heller had defined at the federal level.
and firmly applied it to state and local governments.
using the 14th Amendment's Due Process Clause and the doctrine of incorporation.
A process we saw mirrored in other fundamental rights cases, like Mapp v. Ohio and the Fourth Amendment's exclusionary rule.
And we noted that the specific facts in both Heller and McDonald, those near-total handgun bans, were critical because they directly hit the core of that self-defense right.
Definitely pushed the issue. They weren't borderline regulations.
Right. So McDonald was a huge development, establishing this nationwide baseline for the Second Amendment right.
Absolutely. But, as we discussed, it didn't end the debate. The precise scope and limits of gun regulation remain a very active, very complex, and often contentious area of law.
So maybe the question to leave our listeners with is this. As courts continue to interpret McDonald and later cases like Bruin, how do you see them balancing this fundamental individual right against the government's clear interest in and responsibility for public safety? What kinds of regulations do you think will be the next major battlegrounds in the courts? It's certainly a conversation that is far from over. Thanks for joining us for this deep dive.